My name is Jay Edwards. Remember that the answers given on this show do not constitute legal advice and do not create an attorney-client relationship. For legal advice, you can call the office anytime at 1-800-DeWitt-Law or interact with the show by sending an email to ask@DeWittLaw.com or by calling 407-53-MOSES. That's where you can leave a voicemail. We'll play your voicemail and then get some advice from Mo. Every Sunday morning right here, 10 a.m., you're going to learn how Florida's legal issues affect you with your host, Mo DeWitt of the DeWitt Law Firm. Mo's answering your questions to discuss the latest legal issues affecting the citizens of Central Florida. Not only the citizens of Central Florida, let's talk about one Hollywood actor. Can we go there?
Sure, absolutely.
This is a bizarre case with Alec Baldwin and the whole gun and were there blanks. I mean, I think back to the day with Bruce Lee, way back then, and then something like this happened. So I've always learned, and I have my concealed weapons permit. I have a firearm at home. Yep. I've always learned you never point a gun at somebody unless you intend to protect yourself and kill them.
I mean, that is very good knowledge.
Just never, ever. Loaded or unloaded.
But the weird thing here is it was a Hollywood set.
Mm-hmm.
So, I don't know all the details of it. I haven't followed it super closely. But, as far as I can figure out, as part of this script, at some point, he was supposed to aim and pull the trigger of this gun. So, they charged him with involuntary manslaughter, which is basically you committed some negligent act that led to somebody else's death.
Okay. Is involuntary not as hard to, as far as penalty-wise, as far as voluntary manslaughter?
Yeah, I mean, here you're basically saying there was no intent. You just did something stupid that led to somebody's death. So
I got you.
Kind of the classic example is, and this is a real case, somebody threw a baseball up in the air. It came down on the other side of the fence, hit somebody in the head, and killed them. Kind of a freak accident, but somebody still died.
Okay.
Or, somebody gets in a fight, one punch.
I got you. Okay, one of those. Yeah.
So that's what they charged him here with. But the question becomes, and you're absolutely right, as a responsible gun owner, you never aim the gun at somebody unless you intend to shoot them. But what is the negligent act here? If part of his job as a Hollywood actor is to aim the gun at somebody, can that be considered negligence?
Right.
And if you're going to consider it negligent, then you're probably in a situation where no Hollywood movie or no actor can either use a real gun or have guns in the movies anymore, because there could be potential criminal charges.
Because I guess as an actor, say I'm Alec Baldwin and that's my job, that's my role, and it's my job to shoot Bill in in this movie. I have to assume that props are correct, that it's blanks in there. I mean, nobody in their right mind would ever think that somebody would put real bullets in it.
Which is still unbelievable because they don't really know even where those real bullets came from at this point. But, on Alec Baldwin's charges, you have to show that he did something negligent. Mm-hmm. So, in the prosecutor's statement, they basically said, well, you should never aim a gun at somebody.
Right.
And I think we all agree about that, except if that was his job, I think it's hard to say that he was negligent in doing that. The other aspect I could see them arguing is he should have checked the gun, checked the bullets in the gun.
But how do you know? I wouldn't know, I don't think. I don't know what a blank looks like.
Right, and that's why they have the professional armorer on the set.
Right.
Again, that's not within his duties as an actor on the set. Basically, he's supposed to take the weapon, do the scene, and return the weapon.
Right.
That's really his job. As long as he does that as he's supposed to, I don't really see any negligent act there. Which then, kind of begs the question, why are they bringing charges against him? And obviously, nobody really knows except that they think that they can make a case. Because as a prosecutor, when you charge somebody with a crime, when you say we're going to pursue charges, and remember, they've done about a year of an investigation here.
It's been a while.
So, you're supposed to have a good faith belief that you can actually convict the person of those charges. And nothing I heard in the press conference, again, unless there's something that we don't know, maybe this, when the gun went off, it wasn't, when they were rehearsing or filming the scene, it was him playing around or messing around and he was being negligent. Maybe that's going to be their argument. But from what we know, it sounds like he was, doing his job as an actor and the wrong bullet was in the gun. There were supposed to be blanks and there was live ammunition, which again is unbelievable, and they still don't have an explanation as to where that came from.
Right.
There's always the concern when you're dealing with these cases involving celebrities is the prosecutor trying to make a name for themselves with the media attention and things like that.
Trying to get a book deal, that kind of thing.
You never know.
Right.
I mean, obviously, the charges against the armorer here, I think, are a little more clear cut.
Right.
The armorer was also charged with involuntary manslaughter. Clearly, they did some negligent acts there that led to somebody dying. They didn't somehow live ammunition got on the set. They didn't check the gun properly. I mean, there was a whole laundry list of negligent acts that the armorer did. But if you bring charges just against the armorer, does anybody care? Is that a big media trial? Probably not.
But because it's Alec Baldwin.
That's a big media case that draws a lot of attention. So I hope that's not the prosecutor's intentions. I hope, that they have, done their due diligence and that they, maybe we just don't know the full story yet.
Right.
Oftentimes, as, commentators or people in the media, we're quick to judge, but we're only judging based on the limited information that we have at this time.
Right.
Obviously, assuming that it goes to a trial, that all that will come out during trial, and maybe there's more information there than we know that will show that he did some sort of negligent act. Again, involuntary manslaughter is a pretty low threshold to prove because there's no intent. It's just negligence. So it's a lower standard. You don't have to show that he intended to do anything. You just basically have to show that he did something stupid.
And at the end of the day, somebody lost their life. So if there was negligence on it, yeah, absolutely. Whoever, was the cause of it, absolutely. They need to do the time.
For the person who was negligent.
Yes.
And I think, sometimes, and again, I don't know if this is the case here, but sometimes when somebody is, severely injured or loses their life in a very sad situation, sometimes people want everybody involved arrested and thrown in jail.
Sure.
And that's understandable. The anger is understandable. It's a tragic situation, but we need to make sure that the right people are being prosecuted, the people who were actually negligent and the people who, and maybe even grossly negligent that led to ultimately someone losing their life.
Right. Who put the bullets in the gun? I mean,
right.
And
where did the bullets come from?
And
how did live ammunition get on a movie set is pretty unbelievable.
And we might not ever know unless there's like somebody confesses to it or there's cameras, right? I mean, how else would you find that out? Fingerprints? I don't know.
In a situation like this, on this kind of movie set, I think they were on location, if I remember correctly.
Right.
There's probably not a lot of, surveillance cameras, so to speak. I'm just speculating here. It's probably going to be a lot of witness, interviews, interviewing other people on the set,
right?
Tracing where, the props came from through the prop masters and who made deliveries, who signed for deliveries. I mean, kind of just some, basic detective work to figure out possibly where these things came from, how they were stored, where they were stored, chain of custody type things.
Who bought them, that kind of stuff.
Exactly. So, I mean, it'll be interesting to see, when this unfolds, how it kind of happens, and hopefully we eventually get to see that and get those answers. But at this point, there's still more questions than answers.
Just such a bizarre case, just so weird. All right,
Absolutely.
well, we've got a laundry list of questions to get to. A lot of people love getting some advice from you, so let's go ahead and start with some of our questions. And again, if you've got a question for Mo and you want to send it in to us, send it to ask@DeWittLaw.com. It's ask@DEWITT Law.com. Or again, you can call and leave a voicemail if you want to do it that way, if that's easier for you. Instead of email, you can call 407-53-MOSES, 407-53-MOSES. Leave a voicemail right there. All right, very first one, Mo, here we go. A driver rear-ended me in a parking lot while my car was parked in the parking lot. I wasn't in it, so no injuries. They smashed in the bumper and damaged my trunk. Their insurance company offered me a $450 check. I didn't cash the check. My car isn't new, but it's a 2016. I went to get estimates from a few shops. The shop said it was about $1,500 worth in damage. This has been going on for a month now, the whole back and forth. Where do I go from here? Do I have to take them to small claims court? Any thoughts or suggestions?
Well, you may ultimately have to file a lawsuit and take them to court if necessary, but you have the estimate. Assuming it's from a legitimate shop, you want to take the estimate, you want to send it to the insurance company with a demand that they pay it, give them 20 or 30 days to pay it, and put it in writing, send it regular and certified mail to the insurance company so that's documented. A lot of times, if things aren't documented in these types of cases, the insurance company may not be held responsible. So that's why you always want to document it and put everything in writing.
Okay.
Even put offers that they're making to you, ask them to be put in writing. Now, don't sign any releases until they pay the amount that's proper for the repairs, obviously. But once you've put that in writing, sent them the letter, again, regular and certified mail, and then if they don't respond within the 20 or 30 days, then I would go ahead and file a lawsuit. Hopefully, though, once you put it in writing, they'll act in good faith and offer you fair compensation to get your vehicle fixed. Because obviously, it's a parked car in a parking lot. They can't really claim that you were at fault at all.
Right.
A lot of times what insurance companies will do is they'll say, yeah, there was an accident, but you're 30% at fault. Our insured's 70% at fault. So instead of giving you 10 grand, we're going to give you 7 grand because we're going to reduce it by 30%.
Right.
Here, they really can't make that argument because
you weren't even in the car. Yeah.
Not that I haven't seen them try. They'll argue it wasn't parked properly or whatever.
Right. You were over the line or something.
Right. But at the end of the day, even you could go get 3 estimates as well to make sure that this estimate is in line with fair market value to get the car repaired and submit those to the insurance company. Usually with property damage, most insurance companies I've dealt with are pretty good about paying fair compensation. Now, they can take a long time. They can drag their feet. Again, that's why you want to put it in writing and give those time frames. But as long as it's a legitimate estimate to get the vehicle fixed, hopefully they'll go ahead and get it fixed for you.
I can't imagine going to 3 different shops and all of them come in right around close to that, and then the other insurance company just arguing that no, it's really truly only this much. But their job is to save money.
At this point, nothing they argue surprises me. I've seen it all. And don't get me wrong. I'm sure I know we have insurance adjusters who listen to the show because they've contacted me before. And there's good people out there who work for the insurance companies, but sometimes, they're just not necessarily fair.
Gotcha. All right. We got about 3 minutes left, so let me see if we can squeeze this one in. Is it true that in Florida, you can get hit for attorney's fees for the opposing side, even if you filed the lawsuit under good faith? In the case that you lose the case, or even if you win the case, but it's not by a substantial enough margin of the settlement offer. I don't understand that at all. I hope you do.
Yeah, I do. I'll try to break it down in the 3 minutes we have here.
Okay.
So basically, in Florida, there's only 2 ways to get attorney's fees from the other side. Either there's a contract in place that allows for attorney's fees, or there's a statute in place that allows for attorney's fees. So if you enter into a contract with somebody, it says that if I win, I get my attorney's fees. That always goes both ways. It can't just go one way in the contract. So that's one way you get your attorney's fees if you win the contract, or the lawsuit. The other way is by statute, and we recently talked about this with the roofing legislation. So there used to be a provision in the statute that allowed, if the insurance company didn't pay for your roof, you could sue them, and they'd have to pay your attorney's fees in addition to the actual roof.
Right.
So that's the other way, is by statute. What I think this person is referring to is what we call an offer of settlement. And so basically, I'm going to explain it very briefly because I know we're almost out of time, but as part of a lawsuit, typically in an injury case, you can make an offer of settlement and say, hey, you can settle the claim with me by paying $10,000 within 30 days or whatever the amount is. If they don't accept that and then you go to trial and you beat that by a certain amount, or if the other side beats it by a certain amount, then they may have to pay your attorney's fees. So hopefully that made sense.
Okay. No, that does make sense, because as I'm reading his question, I'm like, I have no idea exactly what he's asking me here. So, all right. Well, very good. Well, listen, if you have a question and you would like to get some advice from Mo, you can email us, ask@dewitlaw.com. Mo, what's the number if they want to send you a voicemail and they just literally, it just says, hey, leave your voicemail here?
It's 407-53 Moses, 407-536-6737. You can leave those messages any time of day.
Okay. And if somebody wants to actually maybe set up a consultation with you or one of your attorneys or somebody like that, what's the easiest way to do that?
Just give the office a call, 1-800-DeWitt-LAW, 1-800-339-4885. We have people standing by right now who can schedule consultations for you, or at least take a message if you have a question as well.
Okay, very good. Well, we've got more of your questions and more advice from Mo coming up here in just a few minutes. You are listening to the DeWitt Law Review right here on 107.3 FM and AM 580, Orlando's News and Talk.
If you follow me for a while now, you know that I'm always posting stupid videos on Facebook and Instagram and TikTok and stuff like that. But what allows me to be able to do that, and what allows me to be on vacation right now, is the amazing team that's behind me who's fighting for our clients in court every day. So just because you see me out here on vacation doesn't mean that we're not in the courtroom right now fighting hard. It's just not me, it's the team that's behind me.
Welcome back to the DeWitt Law Review on 107.3 FM and AM 580, Orlando's News and Talk. My name is Jay Edwards here with Mo DeWitt of the DeWitt Law Firm, getting to your questions. Thanks for your emails. Keep sending those questions to ask@dewittlaw.com or call, leave a voicemail, 407-53-MOSES. And you can call the office anytime if you do need some legal advice and like to set up a consultation. 1-800-DeWitt-LAW. That's 1-800-DeWitt-LAW. All right, next question. This one's a little bit longer, so I'm going to try. I'm going to do my best here. I was slowing down to make a right turn and I was rear-ended. The person that rear-ended me says I cut her off last minute and then slowed to make the right turn, causing the accident, which is not true at all. The police report showed that according to the point of impacts, it was clear I was fully in the lane before slowing to make my right turn. The police report even says that the contributing factor to the accident was the other lady following too closely. Well, shockingly, her insurance took her word for it and found me at fault and will not pay for my damages. Am I missing something here? This accident is as basic as it sounds, but somehow it's my fault. So what are my options?
So, obviously nothing's ever simple, unfortunately.
Never, right?
But, basically, if I had to guess, the other party is telling their insurance company a very different story.
I'm sure.
So usually a police report helps clarify that story because usually the insurance company is going to follow what the police report said. So here it sounds like the other party is basically saying that you cut in front of them and then slammed on your brakes. That's why they rear-ended you.
Right. Which, if that's the case,
then it would be your fault.
Yeah.
So that's probably what the story that they're telling their insurance company. So the first question would be to find out, does their insurance company have a copy of the accident report?
Okay.
Sometimes it can take a few days after an accident for that report to become available. So I don't know how soon this is, but if it hasn't become available yet, they may not have a copy of it. If they do have a copy of it, what you want to do is go back to the area where the accident occurred and look to see if there's any cameras in the area. Because, video footage can be very helpful in these kinds of situations.
Right.
So, look to see if there's any red light cameras, if any of the businesses in the area have cameras that aim on the area. If they do, go talk to them. Or if it's a red light camera or something, traffic camera rather, you probably want to let an attorney know so that they can properly try to preserve that video evidence for you. Beyond that, it's really going to come down to witness statements and then, of course, the actual property damage to the vehicle. But again, if you have an accident report, I've had accident reports overturned before, but usually it's going to take some sort of additional evidence, whether it's witness statements or video evidence or something like that, that the insurance company is going to use to overturn the accident report. So hopefully, in your case, once they see the accident report, they'll reverse course and accept liability on behalf of their insured.
Especially if in the police report they're saying that the point of impact or whatever is it's clear. You would automatically assume that if somebody rear ends you, it's their fault. In my head, that's what I think anyway. Typically it's that person's fault. So I can only imagine going and calling them saying, "All right, time to fix my car," and they're like, "No, it's your fault." Like, wait a minute, how is that possible?
Yeah, what usually happens, or at least what happens more often than not, is you call the other side's insurance company after an accident like this, and they say, "We haven't accepted liability yet." Okay. And usually what that means is, number one, there either is not an accident report, which is why I always recommend getting one if you can, or they haven't gotten a copy of the accident report. And so usually they're trying to track down their insured to interview them and talk to them about what happened, because they won't make a determination as to liability until they speak with their own insured. So usually that's what's happening. And I've seen that process go on for 30 days sometimes before.
Interesting.
It can be very frustrating, very difficult. That's where we kind of step in and try to help people with that a lot of times. But yeah, if their insured's at fault for the accident, they go, "Well, I don't want to talk to the insurance company.
Right.
I'm just going to try to ignore this." You don't have an accident report from the police, so there's no real way for the insurance company to accept liability until they speak to their own insured.
Because they got nothing. And if that person's playing phone games with them,
exactly,
you're going to be in a
very difficult,
long waiting game. All right, I do have a quick question for you when we come back about getting crash reports and accident reports. That'll be coming up next. You're listening to the DeWitt Law Review on 107.3 FM and AM 580. Send your questions. Do I have to email my question to you real quick before I know? ask@dewittlaw.com, ask@dewittlaw.com, or call 407-53-MOSES if you want to leave a voicemail. You're listening to the DeWitt Law Review. We'll be back coming up in just a few minutes. Plus, we got our Mo Pro Tip of the Week on the way.
All right, the crash happened. I was at a stop. The car was coming in. rear-ended me from behind. I was trying to get out of the way, but yeah, that didn't happen. Yeah. After the crash, I kind of sat down for a couple minutes, gathered my thoughts, after the ambulance and stuff. Got discharged, went home. I was really trying to think about what to do next because, that was my first accident. Of course, you hear all the time, call an attorney. So I wasn't really sure what route. I reached out to a friend of mine and she was just like, hey, I have someone you can reach out to. And she said, just call Mo.
Many of our clients are referred to us by friends and family, just like in Jamal's case. It was an honor to be able to represent him and ultimately fight to get him the compensation that he deserved.
My experience with Mo was really good. His team, his staff, very informative. I received all the information I needed, step by step. They made sure I was satisfied with everything, and everything has been really good. They're very detailed. They're very, they call or text whenever they make a move or whatever they're doing. They're mailing out a letter, anything. I'm always in the know, so that's really good on their part. So yeah, if a friend or family member, anyone would ever ask me if they need an attorney, I'll always say, just call Mo.
Hey, thanks so much for joining us and for listening to the DeWitt Law Review right here on 107.3 FM and AM 580, Orlando's News and Talk. My name is Jay Edwards here with Mo DeWitt of the DeWitt Law Firm. Mo's answering your questions, discussing the latest legal issues affecting the citizens of Central Florida. And again, if you've got a question, you'd like to get some advice from Mo, ask@dewittlaw.com is where you can send your email to, and then we'll ask your question on the air, ask@dewittlaw.com. Or if it's something that you'd rather not have on the air, but you do need some advice and would like to set up a meeting with Mo or one of his team members, 1-800-DeWitt-Law. That's 1-800-DeWitt-Law is where you can do that. Back to our last segment real quick. We were talking about getting a police report. Does a police officer have to issue some sort of crash report or police report if you ask for one?
They don't have to. It depends where the accident occurs. If it's on private property, oftentimes they won't come out. And the frustrating part can be if there is an accident, and I'm sure our listeners out there have experienced this before, it can take 4 or 5 hours for Florida Highway Patrol to come out and do a report. And so a lot of times people just kind of want to give up and just say, well, I got the other driver's information. Let's just go on our way or whatever it may be. And so that's where it can be frustrating and difficult. And so oftentimes people say, all right, we've exchanged information. We don't need to get the accident report.
Right.
And then it creates problems down the road when you're trying to get your car fixed, you're trying to get a rental vehicle. It just slows everything down because the first thing the insurance company is going to want to do when they're, looking at the claim is determine who is at fault.
Yeah.
And until they do that, until they accept liability, they really can't do anything for you. So they're not going to start getting your car fixed typically. You can go through your own insurance company, then you're going to have to pay that deductible, which oftentimes people don't want to do. If you don't have rental car coverage on your policy, then you typically want to get a rental car set up through the at-fault party.
Yeah.
So it just slows everything down. It makes things, it can make things be a much bigger headache than they should be, all because you didn't get the accident report, which, I get it. I don't want to wait on the side of the road for 5 hours either.
But the headache in the long run, over the next 30, 60 days of trying to get everything fixed, that 4 or 5 hour wait, I think will probably pay off for you, as far as the frustration of going through it. All right. Next question is, what are my rights when getting pulled over? Other than presenting my driver's license, registration, proof of insurance, do I have other obligations? Do I have to get out? Do I have to answer, why do you think I stopped you? If I think I'm being treated unfairly, can I ask for a supervisor to come, and do they have to show up? I think so. Somebody must have gotten pulled over and didn't like the way they were treated.
So, this is a loaded question, obviously. If you're pulled over, typically, yes, you have to give your license, your registration, your proof of insurance. Now, typically, the traffic stop can only last for a reasonable period of time for the officer to issue you tickets for those traffic violations. Now, if they see other crimes being committed or something along those lines during that traffic stop, then they can escalate it into a criminal investigation from there. And you do have an obligation to comply with lawful orders. If you don't, then you could be charged with resisting arrest without violence. So, I've seen the videos online of people trying to challenge the police, and
Yeah, I see those too. And I'm like, man, are you just asking for.
well, and I always tell people, look, you may be in the right in that situation, but you're also going to spend the night in jail, and then you're going to have to fight it on the back end. So, that's a decision that you have to make. So I always, suggest be polite to the police officers. They have a hard enough job as it is.
Right.
You do have the right not to answer questions if you don't want to, but that may escalate the situation, right? But, if they ask you where you're going, you don't have to answer that. You just have to give them your driver's license, be compliant with the request they made, but you don't have to engage in the small talk. Now, you're probably not going to get out of the ticket if you're being difficult, but that's certainly your prerogative to do so. Now,
Right.
if they ask you to step out of the vehicle, like I said, if it is a lawful command, which as a layperson can be difficult to determine whether it's a lawful command or not, but if you refuse to comply with that, you could then be charged with additional crimes like resisting arrest without violence. And then you can ask for a supervisor. Whether they have to provide one or not, I believe depends on agency policy. I'd have to look into that to be sure. But again, you're now escalating the situation, so I'd only advise doing that if it's really necessary to do so. I'm sure they get that request a lot nowadays with
Right.
all the videos out there. But overall, be polite, be kind, and, if things don't go your way, you can always fight them in court, but I'd recommend trying to stay out of jail if possible.
Yeah, I mean, if I get pulled over, and knock on wood, I mean, the thing that I want to do is I want it to be over and done with as fast as possible. I don't want it to escalate because my biggest fear is going to jail
Right.
for anything at all. And and if they ask me, what did you, was I speeding? Did I forget to signal? Maybe sometimes maybe I just don't even know what I did, but
Yeah.
I am going to comply with you as much as I possibly can. Because, hey, maybe you'll write me for a seatbelt or something, and I've had that happen before.
Right.
Hey, man, you had all your stuff together. Have a nice day.
Yeah.
Thank you I'm like, okay.
Yeah. Now, I have also seen police officers where they will try to trick you a little bit, where they'll say, oh, the driver over there told me you were doing X, Y, or Z, to see if you'll admit to it. So be cautious of that as well. And, that's a question you can certainly say, well, no, I wasn't doing that, or
Right.
I don't know what they're talking about, especially if it's not true. But yeah, I always recommend be polite as possible, answer what you're comfortable answering, but you don't have any obligation to answer those kind of passive questions of just making conversation.
I got you. All right. Next question is, my car wrecked last month by an uninsured motorist, and I only have liability and uninsured motorist insurance. If I do not have collision coverage with my liability insurance, am I out of luck and just have to sue a college kid with my car repair costs? My insurance company seems not to want to cover any repairs of my wrecked car.
So even if the driver who hit you he was underinsured or uninsured altogether?
It says my car wrecked last month by an uninsured motorist.
Okay, so he had no insurance whatsoever. So he was driving on the road illegally because
Right.
here in Florida, to legally drive on the road, you have to have $10,000 in the PIP or no fault benefits and $10,000 in property damage.
Okay.
That's the minimum.
So they shouldn't have even been on the road.
They should not have been on the road. And it sounds like on your policy, you didn't have anything to cover collision, is what it sounds like from what you're telling us. So yeah, you're basically probably out of luck. You could sue the other driver.
College kid. it
College
says.
kid. Good luck collecting. Now their driver's license can get suspended and things like that. But yeah, you're probably chasing your tail at that point.
So they have uninsured motorists, but that doesn't cover the collision part, right?
And so I'd want to look at their policy because I find it a little odd that you'd have uninsured motorist coverage, which covers bodily injury, covers if you were hurt in the accident, but you didn't have the collision because those are kind of, usually if you have one, you have both.
Hand in hand.
Typically, because, typically if you don't have collision, and I guess maybe if it's an older vehicle, you intentionally made that decision. But usually, if you don't have collision, it's an older vehicle and you just don't care about it anymore, or you're going with the bare minimum policy.
So maybe they do and they just don't even realize it. Maybe
it's possible. I would double check the policy, but it's also possible they said, "Hey, they called up and said, hey, how do I save some money?" And they had the uninsured motorist. They had a good policy, and they said, "Oh, your car's 10 or 15 years old now.
Right.
Do you want to remove the collision off of it? That'll save you a couple $100." And they agreed to do that or something along those lines.
How many times have some of us called up and said, "No, I just need the cheapest policy possible for your car"? So think about that when you get your car insurance quoted.
Yep.
All right, next question is, hey, Mo, I was hired January 5th and I was fired January 13th, even after I disclosed my felony conviction to my employer. My employer called me today and said that he can't have me working in his business and he let me go. Can they legally do that?
So assuming this is in Florida, which is where I'm a licensed attorney, so we're going to assume that that's the
Right.
fact pattern, and that's where this show airs. So
Mhm.
we'll assume that
Okay.
that's where this person
For
is.
sure.
Florida's a right to work state, an at-will employment state.
Mm-hmm.
So that basically means that you can get fired for any reason as long as it's not discriminatory. So yeah, they could hire you on and then basically just change their mind and say, we don't want a convicted felon working for us, or we just don't like you, or we didn't like that purple shirt you wore yesterday.
So really, it's that easy.
It's that easy as long as it's not discriminating against a protected class.
Okay.
I actually had a buddy of mine one time who worked for one of the big franchise restaurants.
Mhm.
He went through the entire, he got hired. He went through the entire training, did their whole wine training thing and all this kind of stuff, and then went to go start on his first day, and they realized he wasn't 21 yet, and that he couldn't work there because they required you to pour wine as part of the job. It was just their policy that you had to be 21.
Yeah.
And so they paid him for the training, but they ultimately had to let him go. And so, yeah, that's perfectly legal to do as long as they pay you for the time that you worked. Now, in this case here, as long as they paid you for when you showed up for the
8 days or
8
whatever.
days,
it was,
whatever it was, then it's perfectly legal. Now, if they try to not pay you, then that's a wage and hour violation. There's some other lawsuits that could come from that. But yeah, as long as they pay you for the time that they showed up or that you showed up, and I'm assuming there's no employment contract here, then it's going to be at-will employment, and they can basically do whatever they like to do.
So you come into work, and after a week, boss goes, I just cannot get over your mustache. You
Yep.
got to go. You're fired.
That humming that you make all day, that song that you keep singing drives you crazy.
I had no idea. I guess everybody's always Sue happy, so they want to know,
Yep.
can I get something out of this? But no, I guess sorry, you can't on that. All right, we got time for this one. My mechanic changed my radiator and forgot to top off the transmission fluid. Now my transmission quit, and he gave me some song and dance as to why it quit. It's been there for 3 months now. He claims that he's having a hard time finding a transmission for it. I want him to cover the cost, but I don't think he will. Should I pay him and then sue, or what do I do?
Well, you got a couple options here. So you could pay him and then ask for some sort of reimbursement from him.
Mm-hmm.
Or you could take it somewhere else and get it repaired by a third party. See if they'll render an opinion as well when they're repairing it as to what caused it. And if the prior mechanic was the cause, then you could go back and ask for his insurance information, assuming he has insurance, and bring a claim against his insurance to reimburse you for the cost of the repair. Now, obviously, depending on how expensive the repair is, kind of determines if this is all worth doing or not. Everybody's time has a certain value to it. You would hope that if the mechanic recognizes that they messed up, that they would do the right thing and make the repair for you, do it themselves. That way it doesn't cost them as much money and make it right. But if they're not willing to do that, and you're sure that their negligence caused the radiator here to fail, then yeah, you can certainly have it repaired by somebody else, present the bill to him. If he doesn't want to pay it or his insurance doesn't want to pay it, then you can certainly proceed to either small claims court or file a lawsuit, depending on how expensive it is again, and go after them to reimburse you.
Is there just a general fee? Like, say I wanted to sue my neighbor because they're whatever, they knocked into my fence.
Okay.
Is there like when you go to small claims court, there's just a standard state of Florida fee, like something that is going to cost you out of pocket to sue somebody like that?
Yeah, there's a filing fee in each level of the court. So I think, I don't do a lot of small claims. I want to say it might be $300 to file the actual case. In civil court, it's like $420 to file the actual case. It's a little more than that. It depends how many parties you have, and it also depends on the type of lawsuit. Cases that deal with high-value real estate cost more to file. They can cost up to $2,000 to file sometimes. So there is always a filing fee that you're paying to the county just for the right to file the case. So yeah, if it's $100 repair and the filing fee is $300, and it may not be in small claims. Again, I haven't done small claims in quite some time. But then you have to make a decision. Is it worth my time and money? Am I throwing good money, chasing down bad money that I'm never going to see again? Some people say, well, it's about the principal, and principal can cost you a pretty penny. So it's up to you as to what you want to do there. But yeah, the court system is not free. It's open to the public, but it does still cost money to file a case. Now, depending on the situation, there is you can apply for indigency status where they waive the filing fee for you. in certain circumstances, but you do have to qualify for that.
Gotcha. And you aren't necessarily going to recoup those filing fees in your $300 fence lawsuit.
You may be able to. Oftentimes you can recover hard costs like that, filing
Right.
fee, process server fee, things like that. But you're still going to front them up front. And then even though you may get a judgment against the person that includes those costs, you then have to go collect on that judgment. And if if it's like the case we talked about earlier today, where you're suing the college student who probably doesn't have anything,
Right.
good luck collecting on that judgment. You have a nice piece of paper you can frame on your wall to prove your point, but you may never get paid on it.
Right. You have the satisfaction of, I won. I didn't win
Exactly.
anything, but I heard you win.
Yep, and again, that's the principle of it, and principle may cost you a pretty penny.
Absolutely. All right, we got to one more segment. We're going to get to another one of your emails here and get some questions and some advice from Mo. If you do have an email or a question, you want to email it to us, and we can definitely get to it next week. ask@dewittlaw.com. That's ask@DeWittLaw, DEWITT.com, or you can call 407-53-MOSES. That's where you can leave a voicemail with your question. We'll play your question over the air, your voicemail, and then get some advice from Mo. And again, if you want to call the office anytime, 1-800-DeWitt-LAW. That's 1-800-DeWitt-LAW. You are listening to the DeWitt Law Review on 107.3 FM and AM 580, Orlando's News and Talk. Another one of your questions coming up, plus our Mo Pro Tip of the Week.
So I got a call from a guy last night who was in a pretty bad car accident. He was behind a work truck, essentially. Some items fell off the work truck, went through his windshield, smashed up his windshield, and hurt his hand really bad. So the insurance company reached out to him right after the accident, and he was at first concerned about getting his windshield fixed. I know that doesn't make a whole lot of sense, but his hand was all banged up and really needed to see a doctor about his hand, especially because he does construction work and that's kind of his livelihood. But he was concerned about getting his car fixed, getting it back on the road so he could start driving. So the insurance company sent him some paperwork, and he signed it. And the problem is that paperwork was a release. So basically, he released the at-fault party from any and all liability for a little over $400, basically, which means he can never go after them again. So he called us to see if we can help them. Unfortunately, in this case, we can't help him. He released the other side completely, and frankly, there's nothing we can do. And that's why it's always so important that you speak to an attorney before you ever sign any paperwork with the insurance company. Worst case scenario is the attorney's gonna say, yep, you're good to sign it, good to go. Worst case, or best case scenario, it'll save you from something like this. So before you ever sign a release, before you ever sign any paperwork with the insurance company, reach out to an injury attorney. Most injury attorneys won't charge you a dime to talk to you and take a look at that and try to help you with it. Unfortunately for this individual, it's a little too late, but hopefully somebody else out there can learn from his story and hopefully avoid making the same mistake he did.
Welcome back to the DeWitt Law Review on 107.3 FM and AM 580, Orlando's News and Talk. My name is Jay Edwards, here with Mo DeWitt of the DeWitt Law Firm, answering your questions. Just email them to us at ask@dewittlaw.com. You can call 407-53-MOSES, leave a voicemail right there, or you can also call 1-800-DeWitt-LAW if it's something you want to kind of discuss and get some advice on off the air. Again, the number to the office is 1-800-DeWitt-LAW. All right, we got our Mo Pro Tip of the Week coming up here in just a minute for you, but let's get to this question here. Mo, I'm separated. Our cars are in my name, and my wife left me. She's shacked up with another guy, and they're driving my car. Says she's a drinker, and I found out that she hit a street sign the other day. I'm terrified she's going to hurt someone, and I will lose everything that I've worked for. Can I go and repo the car while she's at work or when it's sitting there at the house?
Well, if you're married, was it married or they were roommates?
Separated.
Separated.
So we're married.
We'll assume that they're still legally married because Florida doesn't recognize separation. So assuming it's married, then it's marital property. So it basically means it was acquired during the marriage. It's both of your property for divorce purposes, basically. Now, if there's a divorce that's already been filed, there may be an administrative order in that county that basically says, you can't go take the other party's car away from them and things like that. Basically, the status quo kind of has to be maintained because they don't want one party trying to gain an advantage or gain leverage against the other party as part of the divorce proceedings. So that may be the first thing that you have to address if there's a divorce filed. Now, let's assume there's not a divorce filed. Then we have to look at just the pure ownership of the vehicle. So if the vehicle is solely titled in your name, then theoretically, yes, you could go take the vehicle. Now, it's important to remember that if somebody else is driving a vehicle that's in your name and they get in an accident, you can be responsible for the damage they cause, just like you were driving the vehicle.
Really?
Because you are the owner of that vehicle, it makes you liable for any action the person in that vehicle does with it.
So his concern about that with the drinking, that's 100% justified.
That's a very real concern. I had a professor in law school who used to say handing someone your vehicle is like handing them a loaded weapon. And that's probably a bit of an extreme analogy, but what he was basically saying is you're liable for whatever they do with that vehicle.
Wow, I didn't know that.
Obviously, it could be a little different if it was stolen or something like that, but assuming you consented to them driving the vehicle, in this case, it sounds like you normally do, then if she's drinking and gets in an accident and kills somebody, you can be sued and you can be responsible for it civilly. You know, not the criminal charges, but civilly speaking. So it's pretty serious. You want to make sure that you're protecting yourself against something like that down the road. But assuming that the vehicle is solely in your name and there's no divorce filed, then yeah, you could probably go out and take the vehicle back. It wouldn't be theft. It would be a civil dispute between the two of you at that point. And clearly there's some safety concerns, given what's going on.
That's crazy. Wow, I just learned something here new today. See, that's why we do this, right? Yep. All right, our Mo Pro tip of the week. We got about a minute and a half left, and I definitely want to get to this. What do you have for us this week, Mo?
So I'm going to talk about something we talked about earlier in the show, is basically if you're ever in an accident, I always recommend that you call the police and try to get an accident report. So number one, pull over to a safe area and call the police. Wait for them to come out and do an accident report. And like I talked about before, that will make your life a lot easier. It will make the process go faster and will go smoother. It will help you get your car fixed faster and get you in a rental car faster, possibly. It can save you a lot of headaches. Number two, take pictures of everything at the scene. I was talking to somebody yesterday who left the scene of the accident where they were not at fault, but they were concerned that the other driver was going to try to argue that they were. And the first thing I asked them was, did you take any pictures of the scene? No, I forgot. So take pictures of everything you can safely, of course, but take pictures of your vehicle, take pictures of the other driver's vehicle, take pictures of the other people who are in the other vehicle and driving the other vehicle. I've had people deny that they were even at the scene before and say, I don't know who was driving my car, but it wasn't me. Take pictures of the roadway where the accident occurred. Take as many pictures as possible and just have that evidence in case you ever need it. Almost act like you need a drone, basically. You're going to try to take pictures of the entire area. I'm not saying you need to carry a drone in your vehicle, but, with your cell phone camera, with the technology, you can kind of do, something similar to get pictures of the entire area and the entire roadway. And then finally, of course, if you need medical attention, go seek that as soon as possible. Don't wait, because if you do wait, the insurance company on the other side is going to argue that any delay in treatment was because the treatment wasn't legitimate, or you weren't hurt from this accident, you were hurt from something else, or so on and so forth. So, but the biggest pro tip there is always get an accident report if you can. Like I said before, sometimes you may have to wait 4 or 5 hours in order to get one, because it just takes Highway Patrol a long time to get out. They're very busy. They're understaffed. So it does take them a while to get to the scene. But ultimately, if you can get that accident report, your insurance company is going to determine liability much faster typically, which means, number one, you may not have to come out of pocket for that deductible. Number two, you can get your car fixed faster. And number three, you may be able to get a rental car depending on the coverage available. So if you can get that accident report, it will probably save you a lot of headache in the long run. And the lady I was talking to yesterday, unfortunately, she did not get a police report. And that's one of the reasons she was concerned, that the other driver was kind of acting hurt, and she thought they may try to bring a claim against her.
Gotcha. All right. Well, there you have it. Your Mo Pro tip of the week. We'll be back again next Sunday, 10 a.m. You are listening to the DeWitt Law Review right here on 107.3 FM and AM 580, Orlando's news.